Yeah, you would have noted that I've just muted everybody. I think there was a little bit too much background noise going on this morning, but Antony, I've asked you to unmute yourself. Kyle, I've asked you to unmute yourself. The session is being recorded, as you can see, so let's get going. All right, good morning, everybody. Welcome to our March webinar. We've got a great registration and turnout this morning, so it's obviously a very hot topic. We always are very appreciative of the time that you take to join us on our webinars, and we're always very excited to introduce you or reintroduce you to one of our colleagues in the industry. This morning, we've got a really great speaker lined up for you, Antony Arvan. He is a close colleague of ours, big shot litigation attorney, which is always nice to work with. After Carl has done a little bit of housekeeping, I will introduce him more formally and then hand over to him. And then Carl and Nicole, if you can just assist me in the background with letting people in, that will be great. And if you do have background noise, please do keep yourself on mute. You are more than welcome to participate. Obviously, post questions on the chat, raise your hand, all those fun things. And then we'll all stick around online afterwards to take some of your questions afterwards. Carl, over to you.
Thanks, Linda. Good morning, everyone. I hope you're all doing well. And thank you so much for tuning into this webinar this morning. This webinar, as Linda said, is going to be recorded and it's going to be published on our YouTube channel. So please make sure that you are subscribed to us, as well as that you turn on post notifications so that you can receive a notification anytime that we post. And then if you haven't already, please do sign up to our newsletter. This way you can keep in touch with the TVDM Consultants team. Then TVDM Table Talks live discussion will be happening next week, Tuesday at 11 a.m. This is a great opportunity to ask our consultants any community schemes related questions you have. It'll also be live. But please note that this feature is only available to our paid for members on our neighborhood. And if you'd like to upgrade your current package, please reach out to me. I'll put my email and contact details in the chat below. And then I also just wanted to say a big thank you to everyone who joined us yesterday at the NAMA Western Cape event. It was really lovely to see you all. And then that's all the announcements that I have for today. I'm going to hand over to Zelinda to introduce the speaker.
Fantastic. All right, let's bring your CV down here. Just a reminder to everybody that all of the information that we're sharing today, the copy of the recording, as well as information relating to Antony, will be made available on our website afterwards, our newsletter, and shared on social media as well. So Antony is a director at Maurice, Phillips and Wisenberg attorneys, having joined the firm in the year 2000. He's an arbitrator and a fellow member of the Association of Arbitrators South Africa. He specializes in dispute resolution, either through the courts or through alternative dispute resolution, such as arbitration, adjudication, and mediation, predominantly in the field of construction, commercial, and property-related issues. Construction law disputes cover a wide range of disputes between developers. We all know about those. Contractors, subcontractors, architects, and other professionals. In sectional titles, schemes, and homeowners associations, you can imagine how many disputes he has to deal with in those instances. Very interesting, at least I believe so, heritage-related disputes in terms of the National Heritage Resources Act. And until 2021, Antony was a member of the Ministerial Appeal Tribunal and the Ministry of Cultural Affairs and Sport Western Cape Government, dealing with all sorts of appeals from the Heritage Western Cape. Very, very exciting. He also deals with disputes arising from the Housing Consumers Protection Measures Act. In other words, disputes with that elusive NHBRC, if we can remember our ABC. So really, really important contact to have. And he deals with a variety of disputes relating to unauthorized building work, again, something we know all too much of, departure applications, servitudes, removal of title deed restrictions, rights-of-way planning approval, and the list goes on. He deals with disputes arising from lease and sale, development of properties, both residential and commercial. And in regard to commercial matters, he covers a wide range of matters, including drafting of agreements, and then, of course, general litigation in relation to a variety of disputes sprung in there for a little bit of good measure. Antony, we're most certainly in incredibly good hands today. So without further ado, I'm going to hand over to you, please.
Thanks, Linda. Welcome and hello to everybody. I don't have much to add. My offices are in Cape Town, although, as you can see, I'm working from home at the moment. That was one good thing that came out of COVID, was the ability to work from home and learning to work from home. I hadn't heard of Zoom until COVID. Apparently, it had been around before then, or Teams for that matter. Yeah, so thanks for the introduction. The talk I'm going to do today is so far-ranging in the sense of the judgments that have come out in relation to CSOS. And the irony is that CSOS was meant to have been this, or created to resolve disputes, or a forum to resolve disputes, stay out of the courts, and we will deal with it internally, similar to how the CCMA started to take labor disputes between employers and employees, not talking about the labor court, but general your run-of-the-mill disputes out of the realm of the courts and deal with it in a forum which is designed to deal quickly, inexpensively with disputes between homeowners, or members in a sectional title scheme or homeowners association. But it has been riddled with litigation, which I want to touch on some of the judgments to try to give a procedural or practical guidance going forward, and can maybe assist yourselves, because there have been some conflicting decisions, there's some uncertainty, for example, and I'll touch on that in more detail just now. Are your rights, if you agreed with the decision of CSOS, to take it on appeal, or are there other avenues you can follow, which there are, but they aren't well explored, and who can take a dispute to CSOS? Must you go to CSOS, etc. These practical, and the courts have given quite a lot of attention to those, and sometimes it's not helped when you've got conflicting judgments. So I'm going to sort of fleetingly look at my notes so I stay on a track, otherwise I could end up going down a rabbit hole, because there are many rabbit holes. But for starters, as we all know, the Act came about to try and regulate the living in either sectional title schemes, share block, homeowners associations. Up to then, there had been different legislation. In terms of sectional titles, there was legislation for that, and that required disputes to be resolved through arbitration in terms of the Arbitration Act. Homeowners associations had no regulation, so it was up to the constitution of a homeowners association to set out how disputes could be resolved. And there was, at some times, would have a domestic tribunal, or it would refer to some organization where the disputes would be referred, but sometimes those organizations ceased to exist, and it became a bit of a nightmare how those disputes could be resolved, or would have to be resolved through the courts. So CSOS came about to try and put all these disputes of call it homeowners, communal living, under one roof. And that's in terms of the Act, the Community Schemes Ombuds Service Act, CSOS Act, Ombuds Act, got various few little not nicknames, but abbreviations. And that came about in about 2011. The clauses which deal with dispute resolution are set out in sections 38 to 48, and that says what sort of disputes can be referred to adjudication to CSOS. Now, the first important definition in the Act is, what is a dispute? It's not just a dispute, but it must be, and in fact, I'll give you the definition rather. Section 1 of the Act says that, defines a dispute as a dispute in regard to the administration of a community scheme between persons who have a material interest. Now, just keep in mind that what I've just said. We have a material interest in that scheme, of which one of the parties is the association, occupier, owner, acting individually or jointly. So before I flesh that out, Section 39 sets out the list of disputes that can be referred to adjudication. I'm sure you're all familiar with them, but if you're not, or you want some refreshing, it deals with a whole lot of disputes that can be dealt with, and that relates to financial issues. And then within that, we'll give you more details of what it means by financial issues, categories, behavioral issues like pets, etc., government scheme governance issues, issues in respect of meetings, issues in respect of management services, issues in respect of works pertaining to private areas and common areas, and general and other issues. Those listed are the only issues which a adjudicator can deal with in terms of the Act. If you can't peg your dispute into one of those categories, CSOS won't have jurisdiction. So what I'd like to now look to is how the courts have determined just those few little words what I've said, which seems simple enough, but they aren't, because people end up going to the courts or to CSOS rather, and CSOS either deals with it and it then gets taken on further on appeal, and the court says CSOS shouldn't have dealt with the matter in the first place. So the first thing is, when I refer to in the definition, where I say remember what I've just said, and that is a material interest in the scheme. Now, there's some judgments which are, I don't use the word more important, but deal more extensively with a lot of issues in relation to the Act and are quite important. I'm going to try to touch on those judgments because they cover a lot of issues, and they're obviously binding. Decisions in the Western Cape are binding in South Africa, in the Western Cape, and a judgment in the Western Cape isn't necessarily binding in another province. But if there is no judgment in that particular province, then it will be binding until maybe a high court in that province reaches a different decision, as we'll see is in the case in relation to the procedure to be adopted. If you go on appeal, there's different decisions. Western Cape has a particular process, while Gauteng has a different process. KwaZulu-Natal has followed the procedure or the judgments in the Western Cape. So in the first matter I want to just touch on is Avenues Body Corporate versus, I can never pronounce the surname, it's Shamaru. I don't know, Zelinda, you might be able to pronounce it. I've never been able to pronounce it. It's spelled S-H-M-A-R-Y-A-H-U. Now, in this particular matter, an owner, after he had sold his unit, was sitting at home and he's probably going, how did they calculate those levies? I don't remember. I don't know how they calculated those levies. Something seems wrong. After he had sold his unit, so he wrote to the managing agents and he wanted to know what formula they had applied in calculating his levy, going back to while he was still an owner and he thought he had been overcharged, and he wanted details of the formula so he could recalculate it. And if they weren't going to give him all that information, he was taking them to CSOS. And they didn't give him the information, so off he trotted to CSOS. And the court determined that he did not have a material interest in the scheme because he was no longer a member of the scheme. So the body corporate was entitled in the circumstances not to give him the information. The court held, no longer being a member of the body corporate, the first respondent, that was Mr. S, his only interest is the remeasurement and possible consequential readjustment of levies, which is a purely financial one. Indeed, he especially confirmed his purpose was to ascertain whether he might have a claim for a refund. His interest at the time he made the application was wholly personal, not in the community scheme, and not in the community scheme. His application, therefore, did not concern a dispute between members with the material interest, that was what I referred to earlier, in the scheme. Accordingly, the dispute did not conform to the defined meaning within the Act. So that's an example of where just a wording in the section can have meaning, and how the courts have interpreted. So ex-members or owners don't have a right, or they may have a right, and they may be able to exercise that right elsewhere, but they can't exercise it at CSOS. The other judgment, which in this category of interpreting what the courts can deal with and what can't deal with, is another interesting matter of Durdok Body Corporate versus Singh. In this matter, the company owned property. It owned about a few units in a body corporate. It was commercial property owned by Ashton Holdings. So the manager of the company said he was authorized to bring an application to CSOS on the basis that this company had been charged for electricity when it was common cause that those particular units had not received the electricity. So he wanted basically a refund, and it wasn't resolved, so he took it to CSOS and for the refund on his electricity portion. The court first determined the matter wasn't resolved there, and the court then determined, the court, sorry, let me go back. CSOS resolved the dispute, but the body corporate wasn't satisfied with it and said that Mr. Singh himself did not have the necessary locus standi to bring the application to CSOS because he himself did not have a material interest in the scheme. And the court looked at that and agreed and said the mere fact that you have authority, as he did, he was the manager of the company, but he himself did not have an interest in the scheme. And therefore he did not have locus standi to bring it, and the matter was thrown out. The other judgment touching on this point, and this is another, it's a very relevant judgment for something I'll be addressing just now, is a matter of Judge Scher of Prague, P-A-R-G, versus Mitchell's Plain Industrial Enterprises, Body Corporate. This involved also commercial property, and certain of these particular units belonging to this trust were destroyed in a fire, and the trust then brought a application to CSOS to hold the manager, or the body corporate rather, liable for not having properly insured all the units as they're required to do in terms of the Act. The court determined that, having looked at all the categories which I've referred to earlier, in terms of section 39, determined that that sort of claim is not one that falls within a claim for damages to a unit caused by a fire, was personal to that particular owner, but had nothing to do with the sectional title scheme as a whole. The court held as follows: the orders on which can be made by an adjudicator in respect of the different categories which are provided for in terms of the Act are primarily directed at matters having a bearing on the sectional title community concerned as a whole, i.e. on members of the sectional title scheme itself and not on individual members. The CSOS Act envisages disputes between members of a sectional title scheme and the administrators thereof, not those personal to the owner. The other damages claimed were personal to the trust as the individual owner of a section in the scheme and did not pertain to the scheme itself, and so did not fall within the CSOS Act's ambit and could not competently be brought before it. The court then also went on to hold that a damages claim isn't the type of claim that also in any event falls within section 39. Another example of where the court said it did not, or the CSOS did not have jurisdiction, is a matter of King's Haven Homeowners Association versus Worker, which is also a very relevant judgment for other reasons I'll get you just now. I see Zelinda's nodding away, because it is quite an important judgment.
I wanted to interrupt you for a second just on the damages one. I think if you can just express again the importance that the CSOS doesn't have the jurisdiction to deal with damages. So
yeah,
in a lot of our matters, we have, where an owner goes to CSOS because of another person's failure, they have experienced damages, like a water ingress matter, a leak, or a failure to maintain, and all of those fun things. And interestingly, one of the prayers of relief is that you can make, or the CSOS rather, can make an order for compensation or to undertake remedial work, but that is not considered to be damages to the extent of it. Yeah. And then when you deal with Kingshaven, that's a matter that's close to my heart, because it was a matter that I worked with first. And I'm so glad that the HOA took it on appeal, because it really is a landmark judgment in homeowners associations. So very, very excited to listen to that. I don't know if you want to comment further on the damages issue.
Are you talking about the Kingshaven judgment?
Yes, yeah.
Yeah, it's a very important judgment for a lot of reasons I'll get you just now, for other reasons. But carrying on with the Prague, sorry, I've lost my notes now, the Prague judgment.
Sorry, I interrupted you.
Yeah, no, I'm going to get to Kingshaven shortly, but just to go back to the damages claim in the Prague one, that's where the fire caused the damage. The court in that case went on to say, in my view, it was never intended that such a claim, in other words, a damages claim, could be adjudicated upon by the Ombud in terms of the Act, which is aimed at resolving disputes in regard to the administration of a community scheme between members who have a material interest, again, those words, therein. If one considers the terms of the Act as a whole and the kinds of matters in respect of which an adjudicator can make in terms of Section 39 of the Act, they either concern regulatory governance issues which pertain to the administration of a sectional title scheme or behavioral issues pertaining to the conduct of members of the scheme inter se, in other words, between themselves. It was clearly not intended that the Ombud would have the power to adjudicate on delictual claims for damages which involve weighty considerations pertaining to wrongfulness and fault. So, yeah, so a damages claim, CSOS will not have jurisdiction to deal with. I've also had people, wanting me to deal with damages claims, specifically water leaks and things, which CSOS won't have jurisdiction. That's your common law right, and you've been entitled. It doesn't mean you're without a remedy. It just simply means you've got to go in the right forum to enforce your claim. So going back to Kingshaven judgment, which Zelinda knows about, which is also a very important judgment. This dealt with the parking bays and etc. So let me just give you a quick rundown of the facts. The facts were that the first respondent, this is Mr. Buerta or Mrs. Buerta, I'm not sure, had repeatedly contravened the association's conduct rules, which required residents to park their vehicles within the boundary of the property and prohibit them from parking visitors' bays. Members of the association had then complained to the association's trustees, and they had attempted fruitlessly to persuade first respondent to comply. The trustees then caused the association to apply to the Ombud for an order prohibiting the first respondent from parking in the visitors' bay beyond these boundaries properties, and the Ombudsman referred the dispute. It was referred to the Ombud to adjudicate. He said he didn't have the jurisdiction to grant the order prohibiting where they could park or not. He said he didn't have that jurisdiction, and that went off to the High Court to determine, and the court agreed that the arbitrator, sorry, the adjudicator, did not have the powers to grant an interdict. That, but went on in itself for the High Court to interdict him, but the agreed that the range of remedies in terms of the Act did not include the granting of an interdict. I'll come back to that judgment just now for other reasons, but that was an example where, again, the court is curtailing and saying and reminding CSOS what it can determine and what it can't determine, and it correctly agreed with the adjudicator in this instance that it couldn't grant the interdict because he didn't have the power to do so. The other one, also to do with an owner behaving badly, was Eagle Canyon Golf Estate versus Grunfeld. That was in Gauteng. And in this case, it's quite an interesting, funny case. Dr. Grunwald violated the scheme's rules and regulations. She drove at an excessive speed. She conducted a business from her residential premises contrary to the rules. She fed the feral cats while she cycled on common areas, and her dogs were left roaming in the common areas. So she was getting fined and fined and fined all the time for all of her behavior. And then Mr. Grunwald didn't like the fact that his wife was being subjected to all these fines. And he then addressed a number of emails to the Body Corporate and complained about the incompetence of the security officers employed by the scheme, raised questions about how the complaints received were dealt with, why there were so many employees at the scheme. And in addition, in the third email, he complained as to why he was issued with speed violation fines and accused the staff of the scheme of being intellectually inferior. And he didn't get a response. They wrote him and said, "We aren't just replying to emails anymore." And the court actually then remarked they're actually not sure why the scheme even bothered to write him that particular email. But in any event, he then referred a dispute to CSOS, where he was seeking, amongst other things, a personal apology for the incompetence of the staff of the scheme. And the court determined that the scheme had no jurisdiction whatsoever to grant that type of relief, and went on to say as follows, that the claim is, which he wasn't asking that the fines be set aside, he was asking for an apology. And the court said that that was a personal, again, of a personal nature, it's got nothing to do with the scheme itself, and then held as follows. More importantly, the relief sought by Dr. Groenewald was of a personal nature and not related to any issues covered in terms of Section 39 of the Act. What she wanted was an apology. The dispute resolution application was not related to an instance of a complaint that the penalties, as I mentioned, were incorrectly imposed. The apology she requires do not fall within the issues forming the subject matter of disputes to be resolved at CSOS as contemplated in the legislation. And it's got nothing to do with the common interests of the scheme. So that is sort of, in a quick nutshell, is where the courts have limited and tried to explain what, when you read Section 39, it's not just, although you might seem to fall within that category, it must still, at the end of the day, not be a personal complaint that you have, like a fire or damages to your unit, or and that you must have a personal interest in the claim. Otherwise, you will not, the CSOS will not have jurisdiction. So the next phase, are we doing okay time-wise here?
Yes, 100% fine.
I'm going to try. It's difficult to rush when there's different, there's different areas. The next question that often comes up is, do we have to go to CSOS? Can't we just go to the High Court? Because this matter is huge. There's going to be delays at CSOS. Some of these adjudicators don't know what they're doing. This is a massive dispute, involves a lot of stuff. We'd rather go to the High Court. And I'm sure you've all come across that sort of complaint or concern. We rather, when you go to the High Court, do we need to go to CSOS right away? And the answer in a nutshell is yes. You need to go to CSOS first and foremost. And that's been dealt with in a few judgments. And slowly but surely, the courts, the attitude has hardened and hardened to the extent that I can say now, don't go to the High Court unless you can show exceptional circumstances. What does exceptional circumstances means hasn't been explained, but you can't say, well, it's very important, or because there are going to be delays at CSOS, or we've had bad experience with CSOS, or they're incompetent, or words to that effect. That's not going to help you. The courts have already, those examples I've just mentioned are what the courts have already said. So I'm not making this up as I go along. The courts have cited that as examples of, don't say that's exceptional circumstances. So the first judgment which grappled with this issue was Coral Island Body Corporate versus Hogg, and that's a Binns Ward judgment. And Binns Ward judgments are in the Western Cape leading the way, in a sense of illuminating some of the areas which are not too clear. And he's standing, and a lot of, like I mentioned just now, KwaZulu-Natal is following the Western Cape, and those are all Binns Ward judgments. So this is the first one where a dispute arose between the body corporate and the owner. The owner had made some alterations to his unit, which weren't authorized. The matter then got settled, except the issue of costs, and Binns Ward was dealing with that judgment. And the approach then, and this was 2019, he said, okay, both courts have got, the court's got concurrent jurisdiction, basically, and there, yes, technically, yes, you can come to the High Court. That was the position then. But he said, he went on further to say, because the body corporate said, well, we can go to the High Court. There's nothing that's stopping us from going to the High Court. And he said the following: the chairperson is technically correct in his assertion that the institution of the application in the High Court, rather than under the auspices of the Ombud Act, was legally competent. but whether the trustee's decision to proceed in this forum was well advised, and whether such decisions should be discouraged by the courts in cases in which the body corporate should more appropriately have proceeded in the less expensive forum that has been specially designed for the purpose by the legislature are quite different questions, and they bear pertinently when the instance of costs of court-related litigation, such matters falls to be determined. So he then looked at the purpose of CSOS, why it came about, was to ensure inexpensive resolution of disputes, which is undermined by referring the dispute to the High Court. So in this case, although he found essentially in favor of the body corporate who took the dispute to the High Court, he ordered that each party pay their own costs. And that can be a significant discouraging factor, that you suddenly have to pay for your advocate, perhaps senior counsel, your attorneys. Even though you win the case, you foot your own bill, and you don't get the other party to assist with the recovery of some of the costs that you would have incurred. So he tried to say, if you come to the High Court, you don't expect to get your costs if you succeed. Another judgment ordered costs in accordance with the Ombudsman order in terms of adjudication proceedings. But then in a judgment of Heathrow Property Holdings versus Manhattan Place, Judge Sher put the matter beyond doubt and held quite clearly the High Court does not have concurrent jurisdiction with CSOS to determine disputes, but can be approached directly in exceptional circumstances. This case dealt with, which is a perennial problem with a lot of body corporates and homeowners, of short-term rentals, Airbnb, etc. And in this case, the body corporate made certain rules which affected those owners who rented out their premises on short-term rentals in Airbnb, and they applied to the High Court for a declarator as to whether or not the body corporate was entitled to make those rules, which they said prejudiced them significantly. The court then dealt with, in a section of the judgment under heading bypassing dispute resolution mechanisms in the CSOS Act, and looked at the judgment I referred to earlier of Coral Island, where the court ordered, Binns Ward ordered that no orders to cost be made. And he said, yeah, but in that case is a bit distinguishable from that, from these particular cases, and a whole lot of other cases where the courts have looked at where a court is entitled to decline to deal with the matter where there's perhaps concurrent jurisdiction, to not deal with it and then discourage the party or make a ruling in relation to cost, but to actually say, no, I'm not hearing it. And the court then said, we don't actually have concurrent jurisdiction. If you look at the powers an adjudicator has compared to what the High Court has, but it's worlds apart. And then slowly looks at the powers the adjudicator has, and I've got 2 pages of what they can do, which I won't tell you because it'll take too long, but distinguishes between what an adjudicator can do. For example, often make decisions relating to fairness, and the High Court doesn't have that jurisdiction. Court doesn't have a fairness jurisdiction. Just for example, I'll deal with some of them. He says the adjudicator has a number of express statutory powers in respect of financial, behavioral, governance, management, regulatory, and other issues pertaining to sexual title scheme, which the court does not have. In this regard, for example, in respect of financial issues, the adjudicator has the power to make orders requiring the scheme to take out insurance. The court can't order someone to take out insurance. To take action under an insurance policy to recover an amount, to declare that a contribution which was levied on owners is unreasonable, and to even grant, it says that even grant an order requiring a tenant to pay over rental, which is payable under a lease agreement to the body corporate corporate and not to the landlord until an amount which is due to the landlord or the body corporate has been settled. The court doesn't have those powers. On governance issues, a lot of the awards that an adjudicator can make relate to whether it's reasonable, rules are reasonable or not. Court can't do that. The court have often said, we can't rewrite your rules. So, and then slowly picks and picks and picks and says many rules or awards that the adjudicator can make, we can't make. And then concludes it. As is thus apparent, the statutory power which an adjudicator has in terms of the act are extremely wide and go beyond the powers which the court has in relation to neighbourly disputes and associations in terms of common law, not only insofar as their reach is concerned, but also in relation to the ambit. In numerous instances, an adjudicator has equity, fairness-based power, not only to decide what is reasonable in relation to the conduct or the decisions which have been taken place by an association, but also to direct what should reasonably be done in place thereof. And he says a high court does not have such powers. He then says all we can do as a high court is to review what CSOS has done. We're not a court, a forum of first instance. We can simply ensure that the CSOS is acting in accordance with its powers and we'll get to the appeals just now. And says the court is empowered to set aside the decision or conduct concerned and then refer the matter back to CSOS. And importantly, whilst there are orders which an adjudicator can make in terms of, he says over here, in this particular matter, they were asking, these are the owners who were not happy with the rules which affected the A&B business, wanted the High Court to declare that the rule was prejudicial and unfair. That's what the order they wanted. So the court said, well, these are the orders which an adjudicator can make in terms of the act. When counsel for the applicants was asked, i.e. by the judge, on what basis the court was entitled to make an order based on fairness, and on what basis the court was empowered to stipulate a period of time for considerations of applications for short-term lets by the body corporate, thereby effectively rewriting one of the conduct rules, he was constrained to concede that he did not have such powers, either statutorily or common law. So that pretty much puts it in a nutshell. And just to sort of drive home the point, he says, that is why adjudicators are best placed to decide on the reasonableness or otherwise of conduct rules and resolutions, and to propose the necessary remedial measures in respect of those which take issue, in respect of which they take issue. If then court, never mind only looking at the powers and the orders it can make, it then says, even look at the procedure of what an adjudicator can do. They can call on someone to give documents. They can call on someone to even come for a meeting in the office. It's all set out in the Act, for example, to provide information or documentation, attend at his office for an interview, obtaining evidence, etc. High Court doesn't have those powers. So draws a significant distinction between CSOS and the High Court and says, don't compare us, we're completely different. And he says, this is where he concludes, it is apparent that the legislature intended that the primary forum for adjudication of disputes in terms of the Act is the Ombud. And by the adjudicators appointed by it, who are required to have suitable qualifications and the necessary experience. The High Court is intended to be a secondary supervisory forum, which is to exercise review and appellate jurisdiction. I'm going to get to the review and appellate jurisdiction because those are important little words he just slips in over there. Oversight of the discharge of the ombudsman, not adjudicatory jurisdiction. And in this case, he threw the matter out and said, I'm not even going to deal with the matter. So he said it's not up to a party to do what he called forum shopping. Where should we go? Which is the best one? Where will we get a better judgment? He's saying, no, you have to go to CSOS. So to the extent that there was any uncertainty in any of your minds before I started speaking, don't go to the High Court as your first port of call, especially in the Western Cape. This is Western Cape judgment. You could have the best case in the world, and the court won't hear it. They'll just, like in this matter, struck it out. So you end up, when a matter gets struck out, it gets struck out with costs. So the other side, who may actually have been at fault, the rules might end up succeeding, and you've got to start again at CSOS. You may well have lost your time periods, because as you know, disputes need to be referred to CSOS within a particular time period. So you could prejudice yourself significantly by knocking on the wrong door. And that judgment, which I've just mentioned, has been followed up in subsequent High Court judgments. There's a matter of Spalding, S-P-A-L-D-O-N-G, Spalding, and there's another one which I've got somewhere, Sorrento sectional title scheme, which is also a Western Cape judgment. If anybody wants these judgments, I can provide them afterwards, or just give me a call or email me or whatever.
Antony, we've shared your contact information on the chat group, as well as a link to consult with you and all that fun stuff. We're also going to get all of these cases from you, at least the references, to attach them all to the recording on our website. So then,
yeah, I'll provide all those judgments. So that covers that aspect. The only other aspect I'm going to cover, so I say I've only got 15 minutes, is the appeal process, and that in itself has been the subject of quite a few judgments. I've only got 15 minutes, so I'm now putting myself on fast forward over here. There's a lot of stuff I'd like to deal with, which for time constraints I won't. So if I'm going to be brief, it's not because I've left things out. Well, yes, I am leaving things out on purpose. So one of the issues which has been before the High Court quite a bit, which has been resolved in the Western Cape, but not so much in Gauteng, is how do I go about, if I wish to appeal? The Actor makes provision, maybe I should just slow down a little bit. Section 57 deals with the right to appeal any decision of an adjudicator, but it's not just a carte blanche appeal or open sesame appeal. Section 57 says it creates a right of appeal and provides as follows: an applicant, the association, or any affected person who is dissatisfied by an adjudicator's order may appeal to the High Court, but only on the question of law. In other words, and that puts quite limits the powers of the court, the appeal court, to determine the dispute. In other words, it can't look at the factual dispute, it can only look at the law and how that has been interpreted. And that in itself has been the subject of quite a few ding-dong judgments of what does it actually mean, this right of appeal and limit to costs. But the courts have generally got over the categorization issue, where Binns Ward initially tried to categorize it as a particular type of appeal. There was a judgment many years ago which referred to the fact that appeal doesn't necessarily, what does appeal mean? And there's three types of appeals. He pegged it as a particular category. The Gauteng High Court pegged it in a different category. And eventually Binns Ward said, it actually makes no difference. I don't really it doesn't really, it's not where you categorize it, but how you deal with it going forward. And that touches then on the procedural aspect. And in Western Cape, based on these judgments, is that if you're going to go on appeal, the procedure to be followed is to apply on motion proceedings, where it's supported by affidavit and all your annexures. While the Gauteng High Court refers to the fact that it must be a notice of appeal, like a normal notice of appeal, which is very limited in information it provides. And Binns Ward, again, in his judgment of Kingshaven, I think that's the one you were mentioning just now, went into detail in that judgment and said why when I say notice of motion, that's an application to court, which you can either go to court by way of a summons, which ends up in court and everybody says, I swear to tell the truth, that's a trial, or by way of motion proceedings. And he was saying an appeal must be by way of motion proceedings, where you file an affidavit and you can then set out basically what the facts are and then why you say it was wrong. Not that you're going into dispute on the fact, but you need to give the court context. And that's one of the reasons why he felt motion proceedings were important and preferred, as opposed to the more short version of the Gauteng High Court. And in the judgment, and that is important because you can't decide, well, we'll just go this route. You've got to, if you're going to go and appeal in the Western Cape, follow that motion proceeding and by way of an application. And in fact, in the judgment of, I'll give it to you now, a Western Cape judgment, the trustees of Alicia Body Corporate, I don't know if anybody knows that particular judgment, versus Cottle, they went on appeal. They were each part, and they brought it by way of a notice of appeal. In other words, not your motion proceedings. Motion proceedings that I mentioned is with affidavit, etc., your normal application to court, while a notice of appeal simply says, I'm appealing for these reasons, boom, 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 and you list it. And then it gets argued. And that's what they do in Gauteng. And the court then, so both, they filed a notice of appeal in this particular matter, and this is a 2023 judgment, 2023-4, which was probably around about about September law reports. And the parties were getting ready to argue the matter. So they brought by notice of appeal, and it was to do with levies, etc. And the court said, before we get into the argument here, why have you gone notice of appeal and not by way of motion proceedings as per the previous judgment, specifically the Binns Ward judgment? They couldn't answer that, appeal thrown out. So it's just struck from the roll, don't go into the merits, start again. But then you start again and you lost time. Now you have to bring a condemnation application, more costs. And by then, perhaps the reason why you went to an appeal could be lost, etc. So don't mess it up by going the wrong way. And it's all about the procedure. And so that's puts it clearly, Western Cape, you have to go by way of application. And if you don't, you're going to lose. It's as simple as that, in the sense of your appeal is going to get thrown out. The last aspect I want to touch on, I've got 10 minutes to deal with it, is this concept of appealing. Is that what I can do? Is that the only thing I can do? So if I've got a decision which is wrong, what are my rights? And you've got your appeal, and is that it? And that is a common held perception that Section 57 is the only way you can take issue with an adjudicator's decision. And that is in fact not correct. There's also the court also has the power to review decisions apart from appealing. There's a distinction between an appeal and a review. And a review, in fact, what I'll refer you rather to is the Act which codified your rights of review. Beforehand, in terms of common law, the court could review a decision to determine whether the way in which the decision had got reached was correct. So, for example, if there was an irregularity in the proceedings, let's say, for example, the whoever was hearing the matter, whether it's a adjudicator, whether it's a school board committee, whether it's whoever, if that decision maker committed an irregularity, for example, was biased, you found out afterwards that he's actually the brother-in-law of the person who is a party to the proceedings, or he doesn't allow a witness to give evidence. Someone to party give evidence says, no, I'm not hearing it. That's not allowing the other side to present their argument. That's got nothing to do with the actual outcome where the adjudicator makes the wrong decision, but is rather the procedure going as to how the decision maker reached his decision, whether that was correct or not. And in terms of PAJA, which is the Promotion of Administrative Justice Act, that call it codified the common law, where a party can require, or any owner or any person, in this instance, the body corporate, any owner can require fair administrative justice. And if a decision falls foul of PAJA, it can be taken on review, in addition to your rights in terms of Section 57 to take it on appeal. And that's quite far-ranging, without going into all the categories of why you can go on review. For example, if there's bias, which I mentioned just now, if the decision is unfair, if the decision maker, and I'm talking from the Act now, but you can apply it equally to CSOS, if the decision maker took into account irrelevant considerations or failed to take into account relevant considerations, if the decision was arbitrary, if it was irrational, if it was unreasonable. I, for example, have taken quite a few matters on review in heritage matters, where the Heritage Western Cape have made decisions that said, no, you can't knock down that building, or yes, you can knock down the building, but we're going to impose the following conditions on what you're going to build in instead. Where we've said, no, there's no basis to limit the developer's right to develop. It's irrational, it's arbitrary, and that goes on review. So similarly, you can take a decision on review in terms of PAJA of an adjudicator. And that particular issue came to the fore, and that's the last judgment I'm going to deal with, and then we will be out of time, is a matter of Gauteng. And funnily enough, this judgment isn't reported, but it's a significant judgment. It might be reported in later editions, was not yet reported, although it goes back to 2020. Sometimes we deal with reported judgments which were given 2-3 years ago. The practice always used to be, as soon as they reported or reportable, they would be reported. Not every High Court judgment is regarded reportable. In other words, it might just be a run-of-the-mill decision or nothing new's coming out of it. But if the court is either making some tweak to or clarifying something, or is breaking new ground, then that's going to be reportable. But if it's just a run-of-the-mill judgment, it's not going to be reported. This judgment hasn't been reported yet. I'm sure it will be, but again, well, time's going against its 2020 judgment of Turley Manor Body Corporate, T-U-R-L-E-Y, Manor Body Corporate. In this particular case, Ms. Pillay, I'll just read the facts quickly and try to paraphrase it. Ms. Pillay complained that certain garden areas were enclosed, permitting these areas to be used exclusively by certain members. These areas were, however, registered as common property and not exclusive use areas. As a result, all members were being charged for the maintenance of these private gardens, but the benefit of those gardens was enjoyed by only those members enjoyed de facto exclusive use. And says, well, why don't I pay towards it? It's not fair. I'm not getting use of these areas. They're effectively exclusive use areas, but why should I pay towards it? And she then took her decision. She didn't appeal. She took it to CSOS, and they didn't find in favor of her. And she then, instead of taking it on appeal, went on review in terms of PAJA. So she had her right in terms of 57, but she didn't avail herself. And you've got, as you know, maybe I shouldn't have said that, but you've got a very limited time period, I think it's 60 days at the top of my head, to take a appeal to CSOS. Sorry, to the High Court. If you're going to appeal, it is 60 days. But she didn't do that, and then she took a decision on review. And the first thing the Body Corporate argued was that you can't do that. You have to go on appeal. You can't go on review. You can't circumvent the time periods in the Act by going on review. And in any event, it's not an administrative decision that the adjudicator has made. It doesn't fall within the ambit of PAJA. The court disagreed. First drew a distinction between appeals and reviews, like I've tried to touch on in the limited time I've had, and then said there's a difference, and there's no reason why, and in this instance, a review is something apart from Section 57. And then said that in relation to this particular dispute, it's incorrect that you only are limited to Section 57. And the court said the first thing to Firstly, the right to administrative action that is lawful, reasonable, procedurally fair is a constitutional right. The PAJA gives effect to that right. An interpretation of Section 57 of the Act that excludes the court's review jurisdiction would exclude the fundamental right to an adjudicative order that is lawful, reasonable, and procedurally fair. This would require language of the clearest kind, not least because such exclusion would be likely to render Section 57 unconstitutional. No such language is found in Section 57. Secondly, Section 57 permits an interpretation entirely harmonious with the right to administrative action that is lawful, reasonable, and procedurally fair. Section 57 permits the adjudicator the freedom to make errors of fact, but not of law. The freedom that freedom has no entailment that the adjudicator may give orders that are irregular or unfair by reason of their non-conformity with the norms of administrative justice as set out in PAJA. Quite the reverse is so. An order may enjoy immunity from revision by a court on the grounds of error of fact. In other words, Section 57 may not apply. But that says nothing at all as to the obligation that an order must be in compliance with PAJA. That lies at the very heart of the distinction between review and appeal. A limitation of the right of appeal entails no limitation of the right of review. Section 57 stands together with the right recognized in PAJA. I find that Section 57 in no way curtails the rights of persons to exercise their rights under PAJA to bring orders of an adjudicator under judicial review, and so on. In other words, he then goes on to say you can review, and in fact, Binswald, in his subsequent judgment, the King's Haven's judgment, refers to a double-barreled approach of you can do both. And in fact, in review proceedings, it's also by way of an application. He says, if you're going to go on appeal, you can go by way of an appeal in terms of Section 57, and then in the alternative, in review in terms of PAJA. And that's the way I would recommend, obviously, if you're fact suited, you can't just do it, is to do an appeal, and then in the alternative, to take a decision on review. So you've got basically two bites at the cherry in terms of two different pieces of legislation. And that is an hour, and I conclude.
Fantastic, fantastic. I've so enjoyed listening to you, Antony. It's been amazing. And when I was copying and pasting from your website, I saw that you had taught LLB students, and I was thinking, damn it, I wish I had just studied a little bit later after my time, and I would have been one of the lucky students to have been taught by you. But
yeah, I lectured for about 10 years at Varsity College, just part-time, which was quite fun.
Amazing. Absolutely amazing. And it's not often that you find somebody in practice that can educate and teach or lecture and vice versa. So I know you're brilliant with both. So that's fantastic. We've had a couple of questions on the chat that I've just answered as we've been going. There's one that I don't quite know the answer to, so I'm going to table it to you. When does one go to the magistrate's court to enforce CSOS orders, and when does one go to the High Court to enforce orders? I know for appeal and review, we go to the High Court, but what is the magistrate's court position with regards to CSOS adjudication orders?
If the Mag Court or the High, it depends on if the Mag Court has jurisdiction over the value, really. If you can't determine the value, then it's better to go High Court. But so if it's, you've got to, the magistrate's court has jurisdiction of up to 400,000 Rand. That's a regional court. The district court is 200,000 Rand. So if your claim or your nature of the claim is going to be, or you can't determine it, then it's better to do it in the High Court, although it may be a bit more procedure, maybe a bit more expensive, but it shouldn't be opposed. It's simply getting it issued. But yeah, that's really the distinction.
Our experience in talking to our litigation colleagues that actually send their candidates off to go and have this issued and stuff at courts, they always say that it's a bit demanding at the magistrate's court and a bit more difficult to get somebody to understand what they're trying to ask for. So perhaps going the High Court route is a bit easier.
Yeah.
Fantastic answer. And then just with regards to all of these cases, I know that the one that you mentioned, or ones that you mentioned, you're going to be sending to us and we're going to link it to the recording. The CSOS adjudication orders, they're obviously supposed to be posted online on the CSOS website. And when the CSOS website does work, it is very difficult to obtain these orders, especially those that are there, because they don't post all of them. Now, with regards to the cases, can you recommend any online resources? Obviously, some are reported and some are not, but the best online resources for our viewers to go and obtain these cases or judgments.
Yeah, the best one to, obviously you can either subscribe to LexisNexis or Juta, but you pay for that. But the best one to get, which deal, or you can go obviously to the Western Cape website or the Supreme Court of Appeal. There haven't been any Supreme Court of Appeal judgments yet on the Act. One may still come out on one or two things, but your best site generally is Safely. I'll give it to you now. I'm just getting up my.
Yes, it'll be great. Thank you so much.
It's SAFLII. Safely. That is your best, and it's very good. I use it extensively, specifically for the unreported judgments. The reported judgments I get through the sites I've just mentioned, or the subscriptions we've got through Jutastat or LexisNexis. But the unreported judgments are all on Safely. And that's where, in fact, I found some time ago, the Turley Manor Body Corporate, some time ago, I was looking for some research. And it didn't seem, I couldn't find much case law. I was looking to go on review in the matter. And and then I found this judgment, which just confirmed there's nothing which said you can't, but the perception was that Section 57 was where your rights started and ended. And Turley clearly makes it clear that that isn't the case. There are other judgments which have also referred to the fact that there is a review, but haven't really gone to the extent of detail that that judgment goes, and clearly sets out why you can go and review.
Aaron Stein made quite a good comment. I'm just going to correct your comment, I think, Aaron. He says, to my knowledge, a CSOS judgment is equivalent to a judgment handed down by a high court. He said magistrates court, but I'm sure he meant high court. It would therefore be futile to go the magistrates court route for enforcement, and whether or not you agree with that.
No, I think the Act actually says you can, specifically says you can do it in the magistrate court or the high court.
Okay, interesting. Hey, gee whiskers. Ladies and gents, if you have any questions, you're more than welcome to pop it into the chat. Otherwise, we can, do you have a couple of minutes, Antony? We can take a couple of live questions if there are any.
Yeah, sure.
Awesome, awesome. So if you have any questions, comments that you'd like to make, you can unmute yourself, raise your hand, put your camera on, whatever works for you. We had a really great number of attendees. I think it went up to about 110, and we had over 300 registrations. So it's most certainly a fascinating topic, and we've had a couple of positive comments that have been made. So Antony, we most certainly might knock on your door to have a follow-up presentation.
Yeah.
Any questions from anyone? Cecilia, I see you've raised your hand.
Yes, please. Can you hear me?
Yes, I can.
I just want to know, so I did post, we have a matter with CSOS. It was lodged in beginning of October, late September. I kept on being told they're going to appoint an adjudicator. We have now recently been told adjudicator has been appointed. In the meantime, the Homeowners Association has taken some of the members, they've issued summonses and so on. And this is at great cost for the owners. Is there anything that a person can do to speed up the appeal that's, or the issue that has been raised with CSOS?
Antony, do you have any positive advice to give?
No, unfortunately, that judgment says you've got to go to CSOS, warts and all.
Yeah.
In the sense that you can't use that frustration you're experiencing, and correctly, I mean, it is frustrating and it can be soul destroying, as a basis to go to the High Court. The courts have clearly said, and there's nothing you can do once you're in CSOS to expedite it. You can write them, you can send them emails, and hopefully maybe one of the emails gets on the desk of the right person, that person then does something.
Yes.
Or to phone.
But if there is a CSOS case, if there's CSOS matter, does the homeowners association have the right to go to an attorney and litigate against owners?
Well, it depends.
The matter, is it?
It depends on what the homeowners is. I mean, the fact that there may be a dispute about something doesn't mean owners can therefore withhold payment of their levies, for example. You still got to pay your levy. So it really depends on the facts, but it doesn't mean the referral of a dispute to adjudication freezes the parties' rights and obligations either way. Yeah.
All right. Okay, thank you.
We very often get the question from our clients as to whether or not simply making an application at the CSOS stops conduct. So can for example, if a body corporate or a homeowners association tries to stop short-term letting, does them going to CSOS making an application mean that nobody's allowed to undertake short-term letting? So the CSOS doesn't have that authority to grant any type of interim relief like the High Court.
No. Can't grant interdicts.
Exactly.
You would have to go to the High Court to ask for an interdict, what's called pende lite, pending the determination of a dispute elsewhere.
Yeah.
So,
Cecilia, to answer your question about the timeline at CSOS, I mean, we can give you some scary examples of matters taking years and years and years and years to get resolved. We've taken a bit of a shotgun approach as to a rifle approach, in that we do copy in absolutely everybody that can be relevant, including the acting chief ombuds, and it normally does work, but not without a bit of pushing and shoving. And unfortunately, you most certainly have to involve a rifle or a shotgun, in other words, a bit of force in your correspondence. So, you know, the best service that we are able to afford our clients is just the correct channels and an audience at CSOS. You have to push your matters. If you simply make an application, sit back and wait for the CSOS to come back to you, you're not going to hear back from them. You might get a very quick response of, okay, we've got your matter, it's being allocated. You might even very quickly get the opportunity to respond to an application. But after that, and especially after conciliation, it can go cold. I've also heard of quite a few matters that were being dealt with by external adjudicators simply falling off the CSOS radar because the external adjudicator is no longer with the CSOS and the files have gone with them. So there's some real horror stories, unfortunately. So you have to keep on top of it. Anyone else? Any comments or questions from anyone else?
Thank you. Thank you.
Okay, so Linda, I will get the list of the judgments to you. If not today, I'll get it to you tomorrow. Or tomorrow's, I'll get it to you. Yeah, I'll get it in the next few days.
Next week. Nothing's urgent. Thank you so much. On behalf of all of us, thank you so much for your time. It really, really was very well spent this morning. Just a reminder to everybody that because the session was recorded, it will be made available on our website. If you've got any questions or comments, I have shared Antony's direct details. Otherwise, you're welcome to contact us and we can put him in touch with you as well. And until next time, keep well. And thank you so much. Enjoy your long weekend for anybody that is making it a long weekend. But we'll chat to you all again soon. Keep well. Thanks, everyone.
Thanks. Cheers.
Bye.
Cheers, everybody.
Bye-bye.